if you were to look at 50 years, 60 years, 70 years back, there were a lot of lakes.
RTC gives us a lot of information about revenue and what has happened, etc. There are two kinds of karab, A and B. RTC also discloses this. Akarban also discloses this. Another important aspect that I forgot to mention is every time you want to construct an apartment, if it's beyond an acre or so, you'll have to give up some of your rights. In the sense, you'll have to surrender some bit of land to the government. So that's when you have to sign a relinquishment deed with the government, with the planning authority or whoever that authority is. Everybody does this. So the JD is done, sanction plan comes in. Before the sanction plan is done, they have to relinquish their rights.
What is the relinquishment deed for? What is the thought process between
the thought process for that is that, let's say you're constructing something on, let's take an example of 5 acres. Now, there could be access issue, right? There are like internal roads. How do you access this 5-acre property? There are internal roads. And you have to have open spaces, right? It's just like constructing a city. It's the same construct. You need to have everything that comes into play.
Everything that's public goes into the government's domain. Okay.
So all these open spaces, because generally all the parks and these open spaces are part of government land. So then government ensures that this is taken away by them, right? Civic amenity sites, that goes to the government. So all these lands have to be relinquished as per the revised master plan rules.
So say there is a property of 10 acres. So could you give us some insight into what gets relinquished from this 10 acres?
So as per the revised master plan rules, depending on the extent of your property, there is X number of percentage which they calculate and tell you. That specific percentage of land has to be surrendered to the government. Only then the government will give you permission to construct.
So this would be roads,
roads, open spaces, parks, civic amenity sites.
All of this coming into your project.
It will be inside your project.
But belongs to the government.
Correct. So let me just summarize. What goes into this relinquishment deed is your internal roads, open spaces, parks, civic amenities. These are certain things that go into the relinquishment. So the structure is pretty similar. Like when you're developing a city, you're accommodating for all of this, right? So the same thing sort of gets transcribed into a thing. But are these roads really public? In view of the government, yes, it is public, but they're treated as private. So there is a deemed lease back that happens. There's nothing that gets signed as such, but then the minute you relinquish and you construct, the government is allowing you to also use it as for your internal purpose. Unless tomorrow the government feels, why does the government do this? Unless tomorrow the government feels that no, there is no access to some part. So you have to open your roads and provide access. Will there be security issues? Yes, of course. I think this happened with one of the brigade.
One of the brigade projects in Bangalore, that's correct.
So it's the call that the government takes. So until there is no requirement for public use, private use is permissible. Once it is required, then yes.
So that means you also have to be cognizant of what is around your property. So if there is a national highway running and then you're somewhere there, it is possible that tomorrow the government can say, no, I'm going to open this up because there needs to be continuity.
It's very difficult to be cognizant of that because there are so many times you won't know.
Okay.
Right? And it's like acquisition. Now, I don't know, I think one of the properties that we worked on actually, some bit of their land got acquired, I think for widening of the road. So these things are something you can't anticipate. But when we do a check, are we looking at an NOC from KIADB or an acquisition authority saying that no land is acquired at that particular point? Yes.
So
we do that check.
So
can we prevent an acquisition from future? Okay.
So it's similar to a P&L statement. So at that point in time, this is the status.
Absolutely.
We won't know what the future holds because there is nothing that allows us to find out what happens in the future.
Very tough.
Yeah. Okay, so what is logically next?
So once the sanction plan is done, and I told you about all the NOCs and permissions, so we'll ensure all that is checked. There are two aspects because a lot of people enter into an agreement to sell when the construction is still going on.
Correct.
Or before the construction even starts. So what we can't verify is an occupancy certificate. So generally when we do this due diligence, we tell our clients that, look, these are the documents you have to ensure that you receive from the builder before signing the sale deed.
So a lot of cases we've seen, I mean, recently in Bangalore, we've seen that there was a forged occupancy certificate. So that is something that can be caught, cannot be caught. How? Because this OC only came out, was forged after an RTI was filed.
Right.
Right? So how do we take care of that? I know that it's not easy for you to also do.
So generally we work on photocopy documents. So we also have a disclaimer saying that we've only looked at photocopy. It's not that we don't want to work on originals, but generally builder, when you're booking an apartment, will never give you original documents. Original really comes through only when, only when you're doing a photo, like a handover.
Takeover, yes.
A takeover by the association.
So to talk about HOTO, we'll do a completely different video on that.
Absolutely.
So that's a much more in-depth conversation. So let's not go into that now, but continue.
Right.
Yeah.
So in such a situation where, let's say that tomorrow an OC is presented to you based on which you have actually bought the property, very tough for you to look at original or not, because no builder will give you an original OC and convince you to come. So it's the representation that the builder does based on which you have agreed to purchase your apartment. So then obviously once you find out that this is a forged document, then you're filing criminal cases and you're taking other actions. But are you a bona fide purchaser? You've done your diligence. You have an email or a representation from the builder saying we've received occupancy certificate, which also gets captured in your sale deed. So basis that, you can call yourself a bona fide purchaser, and that's what you're looking to establish through this entire due diligence check.
Okay.
So I'll just conclude what I was
Please.
saying. So once we look at all of this, there are certain documents that, we may not be able to look at. So what we do is we tell our clients that, look, these are the documents that you need to ensure that you procure before you sign your sale deed, which is your occupancy certificate. And like I said, charges are created, mortgages are created by the builder. So we also have to ensure that a redemption is given. At least what I do for my clients is I take charge. When they come to us for diligence, we also look at their agreement to sell. So at that point, we're already indemnifying them. We put in the necessary clauses in the contract to ensure that tomorrow things go south, you're protected. So that's also something that people need to
South
ensure.
Bangalore is good though. I don't mind going south.
I
I
love South
understand
Bangalore.
I understand what you're coming from, but I want to talk about. Then there are a lot of NOCs, no objection certificates, because of the various statutory requirements.
Absolutely.
Do you also look at the statutory requirements?
Absolutely. We look at NOCs.
Okay.
Like I said, I took examples of some of them.
So fire NOC,
Fire,
your
PESCOM, ॿ
For ST
KPTC,
okay.
yeah. STP, you get a consent for establishment, consent for
for
order,
operation,
all of
that's
that.
it, yeah.
So that also we look at.
Okay. So all of that is also taken care
Yes.
of. So
But one point that I want to make very clear is that we will not be able to verify, let's say for example, if you're looking at STP, we will not be able to verify if the permission that's given to you is absolute.
what do you mean by if it's absolute?
Let's say that through documents we've realized that the builder can construct 1,500
KLD.
apartments.
Okay.
We'll ensure that the consent for establishment is giving you permission to construct or put up an STP for use of this 1,500 apartments.
Okay.
But whether the capacity, for example, that's mentioned there is correctly given is not something, because that comes under expert.
So that's where we come in. That's where 𝗵𝗵𝗵𝗃 comes in to say whether
The capacity is...
Yeah, so the STP built is in line with your 1,500 apartments or not.
Correct.
But what you will be looking at as a lawyer is to see whether they have the CFE for those 1,500.
Absolutely.
Okay.
And
So
also in terms of, today there's a lot of fraud where builders are telling you that I'm constructing on 10 acres, but actually, what you're getting is 5 acres or maybe 8 acres, whatever that is. We will give you an opinion saying this is for 10 acres because your sanction plan will indicate it's 10 acres. There are other documents through which we verify that the land that we're talking about is 10 acres. But physically what you're getting is something that you need to independent, and that doesn't come under the purview of legal
Got it.
work.
So again, people like us, people like 𝗵𝗵𝗵𝗃 would come in and say, okay, you have the builder or the person who's building it up saying that it's got 10 acres of land, and we will do a measurement to say whether the footprint of that property is actually 10 acres or not. Whereas you will look at whether the property that they have claimed is 10 acres and if that 10 acres is legally handed over,
Absolutely.
etc. Okay, so we also look at taxes, right? There has to be taxes. So
what we
taxes
essentially do is, yes, we look at the latest tax paid receipt and also the khata, whether the khata is in the name of the builder, the landowner, So whoever's the last purchaser of the property, the khata needs to be in their name. That's also something that we look at. The latest tax paid receipt. Because if I, for example, were in 24-25, if we have the 24-25 tax paid receipt, it means that the previous year taxes have been paid, because otherwise he will not take tax for that particular year. So we just verify the latest tax paid receipt to ensure that the taxes are paid.
Got it. Anything that you look at in terms of bank NOCs or anything of that sort from the, because the landowner says has got...
Right. So that's the thing, right? I mean, when you... an NOC or a redemption, because usually bank gives either the landowner or, the builder, the mortgage we're
Okay.
talking about.
Yeah.
A situation of mortgage that gets captured in your encumbrance because it's a compulsory registrable document.
Or the
It has
charge,
to,
or
or the
like
charge.
that. So there is a lot of work that you need to do
Absolutely.
to give peace of mind to an individual homeowner. Now, is there anything else that you think comes out of, as the Americans say, out of left field, that somebody needs to be aware of, that you've experienced in your 15 years of work in this field, that you've said, oh my God, I never thought of this, but this is something that I would start doing from today?
From the client's perspective?
From the client's perspective.
That's, I think people are aware. People are aware that they need to do this. But I do see that there is something that holds them back. And what, according to me, holds them back is every property that people purchase, 99% is purchased on loan.
So they feel that the bank is going to...
That's, for me, is very dangerous.
Which brings me to the question, very important question, is how does your due diligence vary from the due diligence that a bank performs?
Fundamentally, if I have to answer this question, it's about each lawyer's due diligence is very different.
Okay.
Now, in my experience, I have seen banks' due diligence is going completely wrong.
Okay.
I can't say at every stage it could go wrong, but there have been instances. Now, by law, bank has the first charge, no matter what. Bank can afford litigation, right? They're sitting on a lot of public funds. So there is an element of risk that the bank has already considered. Are you willing, or the question that you need to ask yourself is that something goes wrong tomorrow because I didn't do the diligence and I relied on the bank. Can you go back to the bank and say, this happened because of you?
Are your
Or
pockets deep
can you
enough-
go
deep
back
enough?
to the court and say, I relied on the bank's due diligence?
Can they technically do it?
No.
No, it's because
That's
you've
how
not...
you
because
have
you're
not
not
done
bona fide then,
Yeah.
right? Yeah.
The bank is doing it for its purpose to give you a loan. Because for bank, it is mandatory that they do a diligence before sanctioning the loan. Otherwise, they're in trouble.
Got it. But the depth of their loan depends on their risk appetite and also how deep their pockets are. Whereas we either don't have the risk appetite they have or the pockets that they have. So it is imperative that we do our own homework so that tomorrow...
Look, at the end of the day, it's important that you take onus for your property and
Got
don't
it.
depend on anyone. Don't say, oh, I bought this from tier 1 and I can't believe I got cheated. Oh, but I went to the best bank and they did their diligence. Oh, I still got cheated. Those don't work. Those are just excuses. It's a very
ignorance.
excuse.
It's just ignorance. Got it.
So, one anecdote that I want to bring to everybody's notice. There was a situation where one of my clients was to buy a property. They came for due diligence. And the bank had already conducted the due diligence and loan was to be
This is
turned.
in Bangalore.
This is in Bangalore. It's an apartment.
It's a tier 1 builder.
It's a tier 1 builder, but this was a resale property that they were purchasing.
Okay. So that means that it has already been owned by somebody.
Already owned by someone. And now my clients wanted to pick up this apartment.
Okay.
Now, the seller who's bought the property, who was trying to sell the property to my client, said that the bank has done, when he bought the property, he said, look, bank had done the diligence and we've gotten the loan. Now, the law is very different for Muslims, Christians, Hindus, etc. in terms of interstate succession. Now, what has happened is, this was a property that was initially owned by a Muslim, which then came to a Hindu. But the way the bank conducted diligence was applied the universal law, like the Hindu law, for a Muslim family and has cleared the diligence, and the seller's gotten loan and cleared, etc. But when the client came to me, I pointed out some very obvious difference in the law, saying, but how could you treat the succession, etc., in this fashion? And that's when the seller tells me that, but bank cleared it. I said, bank may have cleared it, but this is a problem according to me. And if my clients had not done a due diligence, finally they didn't pick up the property because there was some bit of risk in that purchase. But had they not come, and then they relied on the fact that bank has done that diligence.
What is the consequence of that? What would have happened if they
Your
had...
title is not clear. And and that means you're opening yourself up to risk. Which means that tomorrow any litigation can come.
And that means you stand to lose your property.
Either you stand to lose or you need enough money. I mean, there are different ways. It's not that you don't pick up litigated properties, but what you're doing essentially through this due diligence is you're checking your appetite of risk.
So if you have the appetite to
For
take
risk.
care of that risk, then fine, go ahead. But if you can't, then why go into it unnecessarily?
And that's where we come in. Of course, we would advise clients saying that, look, this is the risk that you're going to face if you pick up this property. And this is probably how you can cover that risk. Do you want to do it? Is the question that we leave it to the client, because our job is to educate them saying this is what, and this is a situation that may arise.
Got it. Thank you. So, we've not yet touched upon the 𝗵𝗵𝗴𝗹 HOTO audits.
Yeah.
So I think let's
That
leave that.
requires a different session.
Yes, so we'll do that in the next session. Sure. If the viewers have any questions, they can
I'll be
reach out.
happy to,
Yeah,
yeah.
they can
Yeah,
reach out to you.
certainly.
We will put your contact in the comments, and we'll also talk about your firm, etc., in the contact.
So please, this is not legal advice. I'm not here to solicit my work. This is just to educate the audience. Please do your own verification. Go to your own lawyers, but this is just an educational video only.
Thank you. Thank you for your time. Thanks a lot.
Thank you so
Sneha.
much.
Thanks.
Thank you.